We have a new filing from DMA's attorney, Christopher Cordova, and it is the unopposed motion to continue sentence hearing. No unopposed is underlined. Defendant Christopher Cordova, by and through undersigned counsel, respectfully moves the court to continue the sentence hearing, currently scheduled for July 28, 2023 at 10 a.m. and in support thereof provides as follows. This is weird. This is very weird. As you can see, this was filed yesterday. What's the date on the bottom? 2nd of October. Okay. Right. So that, I mean, the start of this is just stupid as far as I can see. But let's continue reading. Because he's had his sentencing hearing, but I suspect the attorney just failed to change something at the top here, which is a bit silly, but hey-ho. Argument. Federal Order Criminal Procedure 58G brackets 3 provides that a court may issue a stay of judgment or conviction and sentence upon appeal. When evaluating whether to stay sentencing or conviction upon appeal, they look to 18 U.S.C. section 3143, which provides that the judicial officer shall order that a person who has been found guilty of an offence and sentenced to a term of imprisonment and who has filed an appeal or a petition for a writ of certiorari, I know I said that wrong, be detained unless the judicial officer finds A. By clear and convincing evidence that the person is not likely to flee or pose a danger to the safety of any other person or the community if released under section 3142 brackets B or C of this title, and B. that the appeal is not for the purpose of delay and raises a substantial question of law or fact likely to result in 1. Reversal, 2. An order for a new trial, 3. A sentence that does not include a term of imprisonment, or 4. A reduced sentence to a term of imprisonment less than the total of the time already served plus the expected duration of the appeal process. 1. Defendant is no a risk of flight and does not pose a danger to, the safety of any other person or the community. This court is familiar with defendant and is aware that Mr. Cordova is not a risk of flight or to any person in the community. The charges in this case relate to video recording in a social security office, not a crime of violence, drugs, or other concerning conduct. Indeed, the offences are the lowest offences in federal law. Accordingly, the court should find that defendant satisfies the first element of this request. 2. Defendant's appeal is not for the purpose of delay. Defendant intends to present 3 arguments on appeal. 1. That the regulations at issue in this case is a violation of his First Amendment rights to record in public facilities. 2. That the area in which defendant recorded was a lobby for the purposes of 41 CFR 102-74.420, and 3. That the court improperly relied upon charges for state-level crimes for which defendant has not been convicted in determining its sentence. Each of these arguments is made in good faith, based in part on defendant's political activity, and is not made for the purposes of delay. Accordingly, the court should find that defendant satisfies this second element as well. 3. Defendant's appeal raises a substantial question of law or fact. The 10th Circuit employs a 2-part test to determine whether a defendant has satisfied the remainder of section 3143 brackets B brackets 1 brackets B citation. First, the defendant must establish that his appeal raises a substantial question of law or fact, which the 10th Circuit has defined as a question that is one of more substance than would be necessary to a finding that it was not frivolous, it is a close question or one that very well could be decided the other way. As provided above, defendant raises three issues for appeal which raise substantial questions of law or fact that create a close question. Undersigned counsel is aware of no case law across any circuit addressing the right to record in a public space open to the public. Moreover, undersigned counsel is aware of no law interpreting the characteristics of a lobby to permit a reasonable individual to know when and where he can and cannot film for news purposes. 41 CF 102-74.420 provides a list of spaces for which individuals are permitted to film, which includes auditoriums, lobbies, building entrances, and foyers. Each of these is a discrete and different type of space. In this case, defendant entered from a space reasonably understood as a foyer into a space that could reasonably be understood as a lobby. Lastly, defendant intends to contest the government's request for incarceration solely on the grounds that defendant has been charged with 2 misdemeanor offences after this incident. Defendant may very well prevail in those hearings and yet finds himself punished and indeed incarcerated regardless. Again, undersigned counsel has found no case law to support the principle that a court may impose imprisonment on the basis that a defendant has been charged with a separate offence for which he has not been convicted, nor had the opportunity to contest such charges. Each of these bases present good faith appellate issues, which are close issues. Accordingly, defendant has met this third element of analysis. 4. Prevailing on appeal will result in a shorter term of imprisonment, probation, and fees. Defendant is appealing several aspects of his conviction, which may result in a complete reversal of his conviction. Moreover, any appeal will take longer than the 20 days imprisonment imposed by this court. Accordingly, defendant satisfies this fourth and final element as well. Wherefore, defendant respectfully requests this court stay his sentence of incarceration, sentence of probation, and sentence of a fine, pending his appeal of conviction in this case. And as you can see, that was submitted on the 2nd of October. So I'm just going to go back up the top. So he says, this is a request to stay the sentence, fine, pending his appeal. Right, okay. So this is a request of stay of sentence, whereas, I mean, the whole of this, oh yeah, I can hold it. The whole of that just makes no sense. To me, it's not a unopposed motion to continue sentencing hearing, and the attorney has made a bit of a boob there. I mean, there were obviously boobs also during the reading of that. Anyway, be interesting to see what happens. I think the court will probably read it as a stay of judgment or conviction and sentence upon appeal. I'll just have a look at the docket. I know I haven't got it on the screen, but let me just quickly look to see if the docket has any notice of appeal. So it's just this document follows the sentencing hearing. Oh, hang on. He did request the court to stay the execution of the judgment while he appeals the conviction. And the court directed the defence to brief the issue by Monday, October the 2nd. So I imagine it will be read as that with that unfortunate error at the top, because it's not unopposed as far as I can tell. Anyway, thanks for watching.